I'm Sophie Kwasny from the Council of Europe. Pleased to be here. I want to thank Monika. Where are you? You're changing seats.
Just for
convenience. So I have the task to briefly introduce the panel and the panelists. So I want to thank again CPDP for allowing us to discuss this. Last year, Monika and myself, we already organized a panel on internet governance and human rights. So we've tried to bring to CPDP, to privacy experts, internet governance issues, and this time even more specifically addressing some of the concerns. I want to thank ICANN for hosting this panel. So let me first introduce the panelists we have here. So I mentioned Monika as the organizer. So Monika, on my left, is a postdoctoral fellow at the University of Melbourne, human rights scholar and advocate working in the area of internet governance, data privacy, surveillance, and freedom of expression. She's also serving on the executive committee of the non-commercial stakeholder group, which is part of the GNSO, Generic Name Supporting Organization within ICANN. She will mention that. She also co-authored a report of the Council of Europe that I will mention. So next to Monika, we have Stefania, Milan, assistant professor of new media and digital culture at the University of Amsterdam. She represents non-commercial users in the GNSO, again, of ICANN. Okay. Far right, Stefanie. Do I have Stefanie there? No. Sorry, Stefanie. So Stefanie...
Shall I introduce myself?
Yes, please.
I'm Stefanie Perrin. I'm a doctoral candidate at the University of Toronto. I'm basically writing my dissertation on the subject of why ICANN does not have proper privacy protection. I'm a member of the GNSO Council at ICANN and on numerous PDPs or policy development working groups at ICANN that deal with various aspects of data protection and the domain system.
Thank you, Stefanie. Sorry for that. Niels, Oever, head of digital Article 19, co-chair of the Human Rights Protocol Considerations Research Group in the IETF, and chair of the Cross-Community Working Party on ICANN and Human Rights, PhD candidate at the University of Amsterdam. And finally, Corinne, Cath, researcher with the Data Active project at the University of Amsterdam and is currently working on cybersecurity legislation, data protection and internet governance as it relates to human rights. She is a researcher and participant in the Human Rights Protocol Considerations Research Group in the IETF. So we will have a pleasure to listen to the presentations of the panelists. Monika will be moderating the discussion. I just briefly want to mention the work of the Council of Europe in the field, because my organization has been quite active in the field of internet governance for a while, and the work of ICANN in particular. We have had our Committee of Ministers adopting a declaration on the importance for the Council of Europe to contribute to the work of ICANN. The report that Monika co-authored with Thomas Schneider, actually current chair of the GAC, that is the Governmental Advisory Committee to ICANN, on human rights and ICANN, I think really kicked some very important discussions in ICANN, led to the creation of several working groups. You will hear about that. So I think that was very important to mention it. And more directly as to my work, I'm working in the data protection unit that manages the Convention 108 and the Committee of Convention 108, so data protection experts. And the committee has appointed one of its representatives, so it's the Hungarian delegate, to follow the work of ICANN specifically on data protection issues. And we've had the pleasure for the last meeting, and we'll go also to the next meeting, to follow each parts of the various constituencies that can be involved with the topic of data protection to see how we can contribute to that. So, Monika, thank you, and I give you the floor for the rest.
Thank you, Sophie, for such a great introduction into the area. I have to say that I was indeed dragged into ICANN issues by Sophie, and then I'm there, and I think we thought it would be nice to have a panel on this issue because not so many people are actually even aware of what ICANN is, what they do, why it is important, and I think having such an amazing panel, we definitely should try to reveal why it would be important if more academics focused on this issue, because currently it's not so many, and what are the issues involved, especially on privacy and data protection realm, but also free speech, due process, and many other things that are there, and they actually influence and impact all of our lives, because we all use internet, we all use domain names. Some of us have our own domain names and websites. So I think these are the topics that really affects all of us, but we don't know perhaps the way it is done. And so this is the goal of our panel, to raise some awareness and to reveal what kind of issues are involved there. So I would not talk too much. Maybe after that we could have a discussion, but let me go to our first panelist, Stephanie Perrin, who is an amazing privacy expert and has been working on data protection issues within ICANN for a long time. So she would be the best person to introduce you to these issues. So Stephanie, go ahead.
Thanks very much, Monika. And I perhaps should say that I was dragged into ICANN myself by a colleague who had been fighting the WHOIS fight for at least 10 years. And she persuaded me to come in as a data protection expert on an expert working group back in 2013. And I haven't looked back. I realize there's a challenge here. So for the data protection experts in the audience, this is not the most sensitive data in the world. This is a registry data, but let's not kid ourselves. It is a global registry, and there is metadata that is saved and retained. So it is not trivial either, and it sends a very important signal to our whole concept of internet governance in a multi-stakeholder environment that this is demanded by ICANN to be made public. So just a sort of forewarning. Now, I want to go through basically the WHOIS directory and the new registration data services, what they fundamentally are, the privacy issues in that collection, the interventions of the data commissioners over the years, because the data commissioners have not been asleep at the wheel. They have been intervening on a regular basis, and unfortunately ICANN has a tendency to respond to them by saying, thank you for your kind letter. We'll get back to you. The anonymity rights of groups and freedom of expression and association is very important, so we must think beyond the aspects of the individual and legal person. We must think in terms of groups who have websites and their right to anonymous web registration. And I don't think I'll get to what's next, so that'll be over to Niels. ICANN was formed as a California nonprofit corporation in 1998. It is therefore subject to the nonprofit laws of California. California is one of the states in the United States that has better data protection than most, but doesn't seem to be evident at ICANN. When ICANN was formed, maintaining the existing directory of domain registration became a requirement for domain name registrars who were at that point enfranchised or bound under contract with the terms of service through which they were enabled to sell domain names or register them, but it's a sale. Country code registrars have similar responsibilities to make information accessible, but they are totally separate from this particular discussion. This is relating to the generic TLDs. The goal is to enable users of the internet and trademark and copyright interests to determine who has registered names. And that particular goal has been there since '98, since the foundation of ICANN. So the 2013 Registrar's Accreditation Agreement is the latest in, 4 that I've been tracking of these agreements. And as each one comes along, there are more demands for accuracy, there's more demands for more data, and then the data collection and retention requirements are there. So there's basically 3 aspects. Number 1, you will make public the following data elements about registrants. Number 2, you will retain the data for law enforcement purposes 2 years after the last contact with registrants. And number 3, there's a data escrow, which is actually for the benefit of the of the registrants, so that if the company disappears in the night, we don't lose the records of who has what name. So that escrow, however, is in the United States, and the European registrars have informed me they have a hard time finding any other acceptable escrow agent that ICANN will accept. That's hearsay from various PDPs I've been on. So the data protection issues are basically that ICANN is a data controller and therefore should be subject to the rules implied in that. The registrars then become data processors. They also think they're data controllers, but in fact everything they do with data is more or less prescripted by ICANN contract. The purpose of collection, use, and disclosure has gone, despite many, many battles over who is between basically civil society and the other forces that want the data, the purpose is still not clearly stated. And that's a fundamental in data protection law, and the commissioners have come in on a regular basis asking that the purpose be clarified. The individuals are not informed of their rights under data protection law unless the registrars decide to do it, but that's not part of the contract. There are many other obligations on the controllers, or on the registrars, but not that. The bulk access to directory data is required by the agreement. The registrars must enable a certain amount of bulk access, and that has to be in a trade restricted, non-trade restrictive manner. So it's very clear that this data is collected for the purposes of running the domain industry, including to enable efficient monitoring of trademark violation. And the only sort of caveat on that is they're not allowed to spam or market. And value-added services have proliferated. So there's many who was services. And registrants may not be aware of this. As a data protection expert, since I joined this, I've received a couple of plaintive emails that have been forwarded from people who discovered, unfortunately too late, that they put their own personal cell phone in their WHOIS data, and now they can't get it back because even though they're hiring a privacy proxy service to protect it now, it's in the WHOIS. So anybody that wants to find out and get beyond the privacy proxy service simply goes to the WHOIS and finds it there. And in order to get it out of the WHOIS, of course, you can pay, I think it's €15 a year to one of the providers, but there's several, so kind of a mug's game. Registrars in jurisdictions with data protection law are required to seek a waiver of these requirements, and that also is a very difficult process. That was set in a policy about 10 years ago, and I just had the pleasure of participating on the implementation of policy, in other words, the procedures for this. And the registrars are in this catch-22 that in order to exempt themselves from disclosure of who is, which they believe to be in violation of their European data protection law, they have to have an order from a data protection authority that says they've violated the law. Well, by that time, they're risking fines or having their servers seized. So this is not the way you really want to do business. The accuracy requirements are for the purposes of law enforcement, and that includes, when I say law enforcement, there's obviously criminal law enforcement and there's intellectual property law enforcement. And the registrars are forced to verify the data and suspend domains where the contact is in question, the contact details. So you have to be contactable, obviously, if you're running a domain in case there are problems. But if, like me, you didn't check your WHOIS data on the half-dozen domains you own and discovered that the company had made a mistake and put an old address down, all of a sudden you've lost your domains because they suspended it, and the message that you got from your registrar went into your spam folder and you didn't pay any attention to it. That happened to something like 100,000 people when they started to enforce this enhanced data accuracy requirement for WHOIS. And the registrars aren't happy, and some of the users aren't either. I've gone over the data elements, so I'll skip right along here. The data retention elements, which I think most people are unaware of unless they read the RAA, they include the metadata surrounding this, all email traffic, financial information, credit card numbers, IP address. It's actually very extensive for a simple website registration, or rather I should say domain name registration. So I'm just going to skip through the interventions of the data commissioners. The bottom line here is that they have regularly intervened on this and issued opinions, and they're all up on the various websites. The International Working Group on Data Protection in Telecommunications started in '98. There's a common position on reverse directories, which has many elements that are relevant to ICANN. There's the common position on WHOIS, Article 29 comments to the European Commission on WHOIS, the letter to ICANN regarding the one of the first WHOIS task forces, that's 2003, an opinion following that on WHOIS, a letter to ICANN on one of the next processes, which was the WHOIS review. That the policy for the WHOIS conflicts with law was set in, I believe it was 2005. The Article 29 letter to ICANN regarding the 2013 RAA, which is our latest one we're operating under, and the waivers. And this was, if I were a data protection authority, I'd be quite irritated, because the Article 29 group wrote to ICANN and said, we're going to do you a favor. All of the member states in Europe will require a waiver. So this is our authority. Please let these guys off. And ICANN wrote back and said, you're not an authority with legal power. And they said, well, then they wrote back again and said, I don't know whether they actually said, would you like us all to sign this? But they did say that we can certify that all of the countries were represented. And we're still at a stalemate. I mean, we're not getting any further. As I say, this procedure on how to do this conflicts of law just wrapped up about a month ago, and still no resolution. I find it, it's the kernel of my thesis, let me tell you, how they get away with this. Anyway, and then in 2014 also, Peter Hustings wrote to ICANN when he was the EDPS and said that their data retention, which the commissioners had already said, we don't think this is legal and authorized. They said, well, he said the Court of Justice has now thrown out the data retention directive. We think what we told you about ICANN's data retention is also illegal. No response to that either. So I've spoken a little bit at the beginning about the broader issue of anonymity rights in terms of groups. We had a proceeding, lasted about, well, it felt like 5 years, but I think it was a year and a half, on the authorization of privacy proxy services. Because you don't have data protection law enforced, if you want privacy, you have to hire a privacy proxy service. The proxy will then put their data into the WHOIS. The registrars offer these services. Some of them offer them for free because they're well aware they should be protecting it under data protection law. So there was an accreditation issues working group that was looking on all of the various things that were required to accredit the privacy proxy services. And there was pressure from the members of that group, particularly the trade interests, to not allow the use of privacy proxy services for anyone who is engaged in commercial activity and anybody who is not an individual. Well, of course, if I'm running a women's health network in, pick a country, somewhere where women's health networks are not encouraged.
Saudi Arabia.
Sure. Saudi Arabia will do, or anywhere in Africa, really. The pressure on the individuals who have registered the domain is a non-trivial matter. And those individuals may not be entitled to data protection under either the law or in the event that there is no law in the country. So we in civil society are trying very hard to ensure that privacy proxy services remain available for any group that needs it, and that it not be discriminated against, that groups and commercial interests not be discriminated against. Once again, small business operating on the internet is one of the great benefits of it, and if you're going to restrict privacy to not commercial transactions, you're in trouble. Anyway, that's a much broader issue than data protection, though. Obviously, there's a lot of pressure from the IP interests to make sure that the maximal amount of data is available free and publicly in the WHOIS. Now, what's next? We have just started a new policy development process to determine what will be in the new WHOIS. The expert working group that I mentioned I was dragooned into being the privacy expert on wrapped up in 2014. Unfortunately, I had to issue a dissenting report because what looked like good privacy protections were all being blown away by consent, and it was mandatory consent. So you can read my dissent up on my own website, and there's probably a link to it from the ICANN material. So we are now, that report basically has a lot of material in it about some of the recommendations for the new RDS. So we will now start another policy development process to review what's in that report, what's in the preceding WHOIS studies, and determine what's going to be in the new replacement for WHOIS. It's a very important effort, and if anybody would like to sign up and join us, we need all the help we can get on the privacy side. Thank you.
Okay. Thank you, Stephanie, for such great insights. I hope that these things have been interesting for you. And now, perhaps for a slightly different perspective and slightly different organization, Corinne will talk about Internet Engineering Task Force and human rights issues within there. Thank you.
Hi, thank you. Can anybody hear me? Is the microphone good? Okay. So I'm going to talk a little bit about the intersection between the Internet Engineering Task Force and some of the human rights issues that we've been running into there. Now, before you all run out of the room screaming at the advent of yet another internet acronym, let me make sure I'm going through this, explaining it, making sure that everybody's on the same level here, which also means I apologize in advance if this is way too basic for some of you in the room, which it'll undoubtedly be. So the IETF, or the Internet Engineering Task Force, they define themselves as a self-organized group of people who contribute to the engineering and evolution of internet technologies. And they are the most important body responsible for making the standards and protocols or internet specifications that ensure the interoperability of the internet. Without those standards and protocols, we would just have a whole bunch of different networks that maybe can or cannot communicate to each other. So their work is foundational for the internet to be able to function. Now, these specifications, as they often call them, are also named standards and protocols, and they're voluntary standards and protocols that focus on ensuring the interoperability and usability of the internet. They use the slogan, "We reject kings, presidents, and voting. We believe in rough consensus and running code," which should give you a little bit of an idea of the fact that this is a very technical body that sees its work as principally being technical. Just to give a bit of an example of protocols, we know the idea of protocols in the real world as well. We have them for our own communication. So, for instance, for most of us at this conference, if you're to meet somebody you haven't known, you don't know, you would shake hands, and that protocol allows you then to start exchanging information with each other. That's a similar thing for the internet. So you have these protocols, and they enable the exchange of information and data. But the interesting thing about the IETF is that it also has a social dimension to the work, and this is also where the intersection with human rights come, because they themselves define their mission as ensuring that the internet works better. So they say that the community believes that the goal is connectivity, the tool is internet protocol, and that intelligence is end-to-end rather than hidden in the network. So having established all of these things, why is it important to look at the work of the IETF through a human rights lens? Now, standards and protocols shape how information flows across the network. So this also means that it sort of influences the digitally mediated public sphere that we often refer to as the internet, including the type of practices it enables and the rights it protects. I can imagine that this all sounds very abstract and technical, so I'm going to try and give an example of a protocol that, at least in my opinion, has a direct influence on the right to privacy. So we all know HTTP, so the Hypertext Transfer Protocol. And it's a protocol that's used by the World Wide Web to define how messages are formatted and transmitted. Now, recently, a lot of organizations and websites have been phasing out HTTP and replacing it with HTTPS, which is a secure form of HTTP. And so what it does is that it upgrades HTTP by guaranteeing the integrity of the connection between two systems. Now, what does this mean for you if you're an individual end user who is going to a certain website? It means that with an HTTP connection, you have a private and a secure connection. And this means that all sorts of data that you enter into a website, or your browser identity or search terms that you enter into a website, is protected and not leaked. So this is an example where a protocol can directly enhance the right to privacy. So having sort of established the link between the work of the IETF and human rights, it raises a whole bunch of additional questions. And this is something that I've been grappling with as a master student at the Oxford Internet Institute, and now as a researcher for the Data Active project, but also as a researcher on the HRPC group within the Internet Research Task Force, which I'll get back to in a second. But some of the questions that this raises is, how do we talk about human rights in an engineering context? Can we translate human rights principles to technical concepts? And what kind of standards and protocols have a relationship with human rights, and what does it look like, these particular relationships? Now, some of these questions have been at the focus of the Human Rights Protocol Considerations Group at the Internet Research Task Force. Again, lots of acronyms. I'm terribly sorry. It seems to come with this work. So the Human Rights Protocol Considerations Group, or HRPC, falls under the Internet Research Task Force, which is a subsidiary of the IETF. It is sort of the research branch of the IETF, and what they try to do is promote research that's of importance to the evolution of the internet by creating long-term focused research groups. Now, one of these is focused on developing human rights considerations, so a list of things that engineers should consider when they're making their protocols, on what potential impact that these protocols might have on human rights. Now, this work was started by Niels and Avidoria about 18 months ago. I joined roughly a year ago. And the focus of the work, at least from my perspective, because as with everything in the IETF, it's rough consensus. But from my perspective, the focus of the work is to improve the extent to which the IETF ensures that it work is human rights proof. Now, we're doing this through a three-part strategy. So we're trying to map protocols and standards as they relate to freedom of expression and freedom of association. We're focusing initially on these two rights because they have the most obvious connection with protocols and standards. Then we're taking concepts from the RFCs, which are the requests for comments, which are the working documents of the IETF, and we're trying to highlight technical concepts and how they relate or impact human rights. And the last thing is we're building a common glossary that I will leave Niels to explain later. And the overarching goal of this work is twofold. So we're trying to, on the one hand, expose the relationships between protocols and human rights, with a specific focus on freedom of expression and freedom of association. And then what I find the most important part is to actually propose guidelines to protect the internet as a human rights enabling environment in future protocol development in a fashion that is similar to the work that's already being done at the IETF. So the reason why we're proposing human rights protocol considerations is because similar protocol considerations exist for both security and privacy. So this is a format and a way that IETF engineers are familiar and comfortable with, and that fits within the flow of their work. Now, overall, there are several things. I mean, first of all, we could definitely use any kind of input from people who have also worked on this, who have ideas about this, and I'm entirely sure that with this audience, there must be people who have smart and intelligent things to tell us or things we haven't looked at yet. So please feel free to join the work. There should be a link, come talk to me or to Niels about this work. And the other thing is that something that I've noticed being at this conference since the beginning is that when we're talking about internet governance, when we're talking about internet and human rights related issues, there's a lot of focus on internet governance from the perspective of either corporations or governments making legislation or terms of services or other ways, and thereby regulating the behavior of people online, which is, of course, a very valid and important thing to discuss. But we need to also take into account that the issue of human rights online extends beyond this and also touches upon the logical layer of the internet. And I think that this is something that, well, that's one of the reasons that I'm talking here, is to stress that part of it and to make sure that in this discussion about human rights in the internet, we don't forget about the logical layer, because from the outside, it's often perceived as technical and boring, which for the most part, it's not.
Thank you so much, Corinne, for this really helpful overview of the work. And now we can move on to Niels. Yes?
I hope so.
Okay, let's go.
So what I will... yes, excellent. What I will be trying to do is the thing you all did when you first installed Google Earth, and that is zoom out. So luckily, I'll be presenting a trend with Stefania going really into the nitty-gritty, Corinne doing the same with the IETF, and I will try to zoom out a bit and then do the thing that you did after you zoomed out very much with Google Earth, and that is zoom in very hard again. And then let's see if we can do that process together. So working on human rights and the internet is not a new thing at all. Actually, we're relatively conservative and old-fashioned, because in the WSIS, the World Summit on Internet, World Summit on Information Society Summit, human rights were already put as a foundational concept. That was later then strengthened in the resolution on the promotion, protection, and enjoyment of human rights on the internet, in the adoption in the Human Rights Council, which said that human rights as they are enjoyed offline should also be protected online. Then there was the resolution on the right to privacy in the digital age in reaction to the Snowden revelations. And then at a multi-stakeholder forum, the Net Mundial Net Mundial Conference outcome document declared that internet governance should also be based on the Universal Declaration of Human Rights. And then finally, the UN Special Rapporteur also said that governments should promote the use of strong encryption and protect anonymous expression, which is quite interesting because governments have not always been doing this, even though they have accepted these reports. And then we come a bit to the issue of this conference. And it's great to be able to do some conferencing lately. And there's one main trait, and it's when you are with lawyers, they really think that law is the solution to everything. But you're not that special. Because when you are at a technical conference, what do you think is the solution to everything? Well, I tell you, it's not law. And when you're in a multi-stakeholder forum, what do you think the solution is there? And the same in intergovernmental fora. So it might be good to step out of our bubbles a bit and see what it means. Because I think what we need to say to each other is a bit drop our egos and tell us in short that we really do not know how this stuff works. Because the internet is a relative new thing and we're still finding out how it works. But that's also pretty cool because that means that we can still shape it. And what I think is that human rights is something that we can relatively agree upon. So maybe use that as a common denominator and build for that. And for that, luckily, we need you lawyers. So there is a place for you. That's great. So if you then look at what the internet is and what it encompasses, I'm using Lawrence Lessig, who said that the internet and its policies are a combination of societal values, public opinion, law, the market, and the internet architecture. So there is none of these places that can do everything. We need it all. And what I will be mostly focusing on is the intersection on architecture and law for the moment. And then now I'm gonna zoom in a bit on the Internet Engineering Task Force and protocols and human rights. So standards and protocols can be seen as the basis of the internet. We're talking about internet infrastructure here. So when we talk about internet infrastructure, there is both the physical layer, which is the Wi-Fi, the cables, the subterranean cables, and then there is the logical layer that combine these things. But for all these things, standards are necessary. A Wi-Fi standard is needed, so Wi-Fi devices can communicate with each other, but also HTTP, TCP, IP or more modern things where we maybe soon will be using UDP. Yes, I know a lot of acronyms and it's not good. So often also, so standards are crucial for intercommunication on the internet. Because why is the internet a success? Because there is this thing called open innovation. You can connect your network to the other networks. The internet is this network of networks. And because we choose to speak the same language, we can play a bit. But I can also decide to do something new. And if I can then convince others to do that as well, then we can communicate and do something new. So we do not need permission from a government or from a standard body to actually do something on the internet. So standards and protocols are the basis, but we also often see the internet as a right enabling or at least a right impacting environment. So one could think, you know, is there a correlation between these two? Well, luckily, the Internet Engineering Task Force already says something about that, even though that is not always carried by all the engineers, because then you get into the discussion when you bring in human rights, well, but technology is neutral. Well, maybe not. I don't think so. And luckily, the IETF also has a clear objective, and that's like the goal is connectivity, the tool is the internet protocol, and intelligence is end-to-end rather than hidden in the network. What does this mean? The internet should do nothing more than run packets from the one side to the other and not do innovation in the middle, but we do that at the end. And it's very important because that allows us to keep on working with the same standards and then keep developing at the end. So if something new gets invented, it doesn't need to run through new hoops. But also in its mission statement in RFC 3935, it says that the internet isn't value neutral, and neither is the IETF. So we embrace technological concepts such as decentralized control, edge user empowerment, and the sharing of resources. And these concepts have little to do with the technology that's possible and much to do with the technology that we choose to create. So that is really quite a strong mission statement. But funnily enough, is a lot of the things that get created in the IETF and many standards, such as the end-to-end principle, are broken on the internet. And it's important to remind then again that these protocols are voluntary standards, and IETF is not the protocol police. It's not if you use an implementation of a protocol differently than it's described, you're going to get kicked off the internet. No. What is interesting is that there is an increasing work on security and privacy. And here you see the amount of security mentioned in internet standards in related to privacy. And you see that security is maxing out at around 1989. And that is when security considerations became obligatory in internet standards. And you see that privacy is also gaining some interest. But when you then actually see the length of the security considerations, that's actually relatively short. So the amount of time people think about security might still not be as long as we want it to be. So for our work, so we've seen security, there are security considerations, but there are now also privacy considerations for internet protocols. So if you design internet protocols, how do you think about privacy? So when we saw security, privacy, both human rights, what about freedom of expression and access to information, freedom of association? How can we translate those technically? Well, we had a try. So we started off with freedom of expression, and then started understanding, well, content agnosticism, connectivity, privacy, security, open standards. We thought a bit more, because then we thought we shouldn't let ourselves off the hook, because you can put broad concepts like connectivity and security, but if you do not define them precise, it doesn't say much, right? Because we really want to operationalize human rights. And then things can get a bit more complicated, but then we are reaching to something that's really concrete, that when you're building a protocol, that you could think about these things. And that's what we're actively doing in the research group. And while we were at it, we also came up with the definitions for some other rights. So while you're all very capable to read, so I'll just sift through them shortly. And you can also all find them on the website of the research group, which I'll share with you shortly. And now we quickly move back to ICANN. So ICANN is very big, very comprehensive, and I'm sure you all know a lot. So you all familiar with what the domain name system does? Who knows what a domain name system does and how it works? Very good, very good. So ICANN is like the overall telephone book with which the registries and registrars siphon up, gets into ICANN. And ICANN then does the coordination for the names, but also for the IP addresses that are handed out and then distributed via the regional internet registries. That's great, and I can skip this. So there are, so a lot of people here and in general really are hating on the multi-stakeholder model, which by all means, but there are so many different forms of the multi-stakeholder model that it would be great that the next time you are hating on the multi-stakeholder model, it would be great if you say which one. Because one could argue that in the IETF we have a multi-stakeholder model, but in ICANN as well. But in ICANN we are organized in small constituencies that have their own mailing list and voting and policy development. And in the IETF we simply have working groups and with mailing lists to which everyone can subscribe. What is really good is that in both these fora, transparency is very important. So of almost all calls, of almost all mailing lists, you can find transcripts and archives, which is really quite interesting, but can also be quite daunting. So ICANN roughly has two arms, the policy development arm and the operations arm. The operations is keeping the things running. That's what the ICANN staff does, and oversight by the ICANN board of directors. And then there is the policy development process, where the community comes together to develop policies. And then there are the governments who are organized in a governmentary advisory committee who advise the board on things that are going on. And at the same time, yes, I'm hurling information at you, but you can process it, is we are moving away from American oversight to ICANN to an internationalized internet community oversight over ICANN. So John Postel was the person who managed the DNS on a computer under his desk, funded by the US government. When it became too much for John Postel, ICANN was set up to manage it, but that was still under the oversight of the US Department of Commerce. Over the last years, a lot of comments were made that this actually should not be happening if we have a global internet, that the US government has oversight over this particular part of critical infrastructure. So this plan came that it should be handed over to the international internet community. And for that, two processes were started, like come up with a proposal for how is this technically being done, and otherwise, how are we going to improve ICANN's accountability? The technical part is done, and we're in the last phases of the cross-community working group on improving ICANN's accountability. Why is that important and relevant? Well, because ICANN's policies and operations have the potential to impact human rights in many different ways. So Stephanie talked great about privacy, but there are also freedom of expression forms. So one can think off the cuff of your hand about .amazon. Should it be for the company, or should it be for the governments that are through which the river Amazon is running? You can also think of Ajax, but there are also issues like who should be able to register and manage .islam or .gay. In these first GTLD process, the global generic top-level domains, was that communities have priority over other groups that try to get a domain. And hotels have been able to show that they are a community I did not know of. But unfortunately, the gay community was, according to ICANN's independent evaluators, not able to do so. So you see there are quite some issues here. And also if you see that these new domains are mostly all registered in the global north and not in the global south. So there's also clearly an economic and social rights issue there. So in this transition moment in the cross-community working group on accountability, we managed to get a commitment, or the text for a commitment to for ICANN to respect human rights. And we almost have a consensus on that in the working group, on which we had a third draft report on which there were comments. But at the right now, it seems that even though the whole working group agrees, only the board is pushing heavily back. And it's quite interesting in the model how the cross-community working group on enhancing ICANN's accountability is set up, because we're talking about the accountability of the board, but the board is strongly pushing back on improving its own accountability according to international human rights. When we talked about human rights for the first time in ICANN, the CEO of ICANN, the chair of the board of ICANN, Steve Crocker, said, "Human rights is all great, but I have no idea what it has to do with ICANN." Well, right now we're a year later, and the board has changed its opinion, and they right now say they have a very strong commitment to respect human rights, but they're not ready to make a bylaw commitment because they think it's premature, which is quite interesting, 60 years after human rights have been adopted. So, but this is something that we're working hard on, and you could even join in there. And for that, we have another body set up. We love creating bodies and new groups, but we Dutchmen love that. If there are like 2 Dutchmen people, you had 2 Dutch people meeting, you have 3 organizations. It's great. So there's the Gross Community Working Party on ICANN's corporate and social responsibility to respect human rights. Yes, that's a consensus title. And with that, we're trying to converge all the activities in ICANN and human rights, to have people who are interested in this, to have one place that they can come to, and we can guide them and help them participate in the processes. So if you think this is interesting, please have a look at these websites, join the mailing lists, feel free to ask questions, because we would love to have you there. Thank you very much.
Thank you, Niels, for this passionate overview of what is going on. Now I would like to invite Stefania Milan to give us a little critical perspective on the multi-stakeholder model, and perhaps put the policy and advocacy and civil society in some sort of perspective of what we're doing there and how you perhaps could also contribute. So, Stefania, go on.
Thank you, Monika. Thank you, everyone who have so far contributed stories about their very intense activity within ICANN and the IETF. As you can see, we are not only a little crazy because we do this, but also extremely passionate about it. So what I'm going to do is try to zoom out even further, to use Niels' words, and provide a little of a perspective on the multi-stakeholder governance model as it is implemented within ICANN. And this is not just because ICANN sponsored us and ICANN is even sitting right in front of us, but because, well, it's also in reference to what we have heard yesterday, several people trashing the multi-stakeholder model. And, well, not that we actually disagree with that exercise of trashing it, but Niels has also pointed out that there are many forms of multi-stakeholder decision-making, governance model, whatever you want to call it. And it's important to contextualize them. It is nonetheless a very important opportunity that is offered to people like us who have values and ideas and would like to advance them in a setting which is particularly transparent and particularly open and permeable to our instances. Now, whether we actually take home what we want and fight for is not a given. It takes a lot of energy and a lot also frustration occasionally. But, well, there's value into that. So that's what I'm going to try to convince you about. There were some questions in the abstract we submitted to the organizers of this conference, and these are questions that have not been yet addressed. So one is what's the role of different communities within the multi-stakeholder model in internet governance as it relates specifically to infrastructure development, and who in the community is to ensure accountability. And the accountability issue is something that we care very much about, in the sense that we try to also hold ICANN, for example, accountable, but it's something probably we ourselves fail a little bit at taking into account, and it's one of the problems I would like to address. So if you want, this is a sociological take, or sort of critical governance studies perspective on the multi-stakeholder, looking at obstacles and possibilities. And I'm going to be very brief and reflect on 3 myths, if you want, that are associated with multi-stakeholder governance. So it's the myth of openness, the myth of equal footing, and the myth of the common ground. And I'm doing so from the perspective of the civil society in particular, because that's what we are discussing here. Now, of course, because we're not alone there, unfortunately, then other players come into the game as well. Now, it is true that if we look at ICANN in particular, and the Internet Engineering Task Force even further, there are a lot of mechanisms that actually facilitate access on the one hand, but also effective participation in policymaking. I mean, you have heard, all the working groups that were mentioned, probably also very, very confused by that. Well, there are many, many others that were not even mentioned. But you also heard, for example, the Generic Name Supporting Organization Council, where, for example, Stephanie and I sit as 2 of the 6, if I remember correctly, representative of the civil society. So in principle, also representative of your instances, the instances of the users. So there are provisions, there are mechanisms, spaces, formal or informal, to participate and access. And so yes, it is good. It is unusually good if we look at these spaces, but yes, at the same time, it can also be improved. And yes, it is also a little frustrating sometimes. So the myth of openness. Yes, the door is open, but who gets in? Now, whoever is around is the answer. So, well, you have nice people like us, and you can trust us that we are fighting for the global common good. But it's also true that there are also other people who are probably less nice than we are. And the thing is that you have to trust us all, right? You buy a sort of package of civil society, and you hope that there's not too many distortions and that people find a voice to speak together. So in a way, in the same way in which we're very worried about the accountability of ICANN as an organization, for example, we are not particularly good at holding ourselves accountable. And in the sense that we are who is around. We are who has decided to make time, and we are a mix of academics who then do it as part of their mandate as academic, their mission as academics, but also because they have a little more time than others, so they can build the time in a way that also makes room for all the crazy calls in the middle of the night that you have all the time. And you also have NGOs that have made of lobbying ICANN, lobbying the Internet Engineering Task Force part of their mandate. But unfortunately, there's not much diversity. Mostly white, Western-based people. And if we are a good proxy of who is there, not because we don't want other people to come in, but because it's again a matter of resources. You have to have high-speed connection. You have to have time. You have to have skills. Skills can be built, but the learning curve is tough, and you need essentially time and patience. Because yes, everything is available. You have all this, every single word more or less that is spoken within ICANN, for example, the IETF, is there. But good luck with finding it again, and good luck with reading all those materials. So it's a matter really of resources, which brings me to the second of the myth associated with multi-stakeholder governance, which is the myth of the equal footing. Now, is civil society really standing on equal footing vis-a-vis the other players? Well, unfortunately, not really. There's a lot of work being done. There's a lot that can be advanced from our side, but unfortunately, we also have to spend a lot of time trying to defend the model. So we are also particularly passionate about defending it. So the process itself, defending the process and trying to improve it. And a lot of the discussion, a lot of the energy also goes to that. But again, it is a matter of resources. It's a matter of time, and it's a matter of skills. I mean, when you look at whoever is around from the civil society, unless they're funded by their organization, well, we cannot have the lobbying power of the industry, for example. But this you can already guess by yourself, because it's the same in many other sectors, unfortunately. And then the third myth associated with multi-stakeholder civil society participation, multi-stakeholder governance, which refers to the common ground. So is there a civil society which can speak with one voice and make itself heard loud and clear? Well, thanks goodness, no. There's more than one civil society, and there's more than one agenda. And very often, items in such civil society agenda are even contradictory. Sometimes we have more disagreement within our sector than we have, for example, with, the intellectual property rights people, which, at the face value wouldn't really something that you respect. So you have sometimes very unusual alliances that emerge between civil society people, groups, subgroups, sub-constituencies, and other groups, and it is really done on built basically on specific issues. Unfortunately, and this is my last point, there's not much space for disagreement within the multi-stakeholder governance. It is confusing for ICANN as an organization that we speak with different voices, so we should probably also try to, be one in the face of the organization, in the face of the other forces that we are trying to fight, if you want. So we should probably not show disagreement, and that's one of the problems of the multi-stakeholder model, that it's really inherent in the decision making and in the way we relate to each other, and it's not yet been solved. So to conclude, there's more space for people to get involved, and you already heard from other people here, but merely from the academic point of view, being involved in this type of processes at this specific moment in time, it's a great exercise of observing, for example, institutional design as it evolves, and in a way that puts together values, different agendas, and infrastructure and code. So it's a very, very interesting time. So it's good to criticize it. It's good to criticize it to make it better, but probably participating. There's the room for more academics to get involved, and we really need you in there. Thank you.
Thank you, Stefania, for a great step back and reconsideration of our values and our participation. Before we open the floor to questions, I'm sure you'll have many, I would like to give a quick word to our chair. So, Sophie, go.
Thank you, Monika. Yeah, just a quick reaction, sorry. Niels. Yeah. No, thank you very much for being here. I think I want to say one thing. I knew that if we were going to discuss internet governance, there would be multi-stakeholderism questions raised, and that's great. I come from an intergovernmental organization, so this is our identity. I'm a lawyer myself. Nevertheless, we've tried to bring, and for internet governance issues in particular, we've really tried to promote, and we have political declarations with this language saying that multi-stakeholderism is a necessity, we believe in it. We try to support as much as we can. I want also to congratulate the organizers of this conference, because it's the 9th edition. I've been to several privacy events, and this one, and this is the reason why I like it so much, is that it's multi-stakeholder. You have IT engineers involved since the beginning and for years in the work, and you have really a rich exchange in this conference. And last thing, I don't know which panel you attended about those critics on the model, but I heard one indeed yesterday. But in the end, what I retained from what the speaker said was that it was just normal to involve every interested parties in this democratic process. So that's what I retain of it. But thank you very much, and thank you, Corinne, also for the presentation on the IETF. Thank you.
So perhaps we should open the floor. Please go ahead if you have any questions, and we can... for particular panelists or overall, we see one hand at the back. So let's start with that. Gentleman over there.
Does it work? Yeah. Thank you very much for the presentations. I have one question which regards the interaction between the different normalization fora. You mentioned the ICANN, the IETF. I am myself as a researcher working a bit on the W3C, which also has a privacy interest group. And I guess there are also many others. There is ISO that was mentioned in another panel and so on. How does the relation work between these different people? If you're in an organization, do you have a strategy to be in as many organizations as possible, or do you focus on standardizing organizations that you believe are really key, and which one are they? And yeah, what are your thoughts about this interaction between the different fora? Thank you very much.
Thank you. Who would like to address this question? Maybe Niels?
Yeah, because it's great that you asked this, because I'm only at the start of my wondrous quest through a standards world. And so I've been in ICANN, IETF, and W3C, definitely important, but also the IEEE and ISO and the ITU, all set very important standards. And all these different bodies had different methods for engagement. So that's something that we're trying to do, and also trying to understand first, how can you engage, and then how can you understand what are the relevant topics that are being discussed here? And that, frankly, just takes a lot of time. So, so the next one on my list is the ITU. I was at the it's relatively random. I was at the plenipotentiary meeting. I thought, interesting, let's do this. But W3C is again different from the IETF because it's a membership-based organization. Same with ISO and the IEEE. So all have their own perks, and I think we should really study them and engage with them because the infrastructure has and the standards and protocols have a crucial impact on the way technology is shaped and how they impact our rights. Because it's really simply like public infrastructure. How do we have roads? How big are they? Do we have sidewalks? How do we mold our public spaces? How we can exercise our rights?
And also, Stephanie would like to top this up, I guess.
Yeah, and I do think this is a critical problem with the multi-stakeholder model. As Stefania says, you know, is it really working? It's who is there. Now, there is a Security and Stability Advisory Committee of ICANN, and there's a great deal of overlap between the IETF and the guys that and folks that are on the SSAC, the Security and Stability Advisory Committee. Some of those also are active on IEEE and ISO standards, and some of them are also active on W3C, I believe. From the civil society perspective, I know I've been active in ISO on quality standards with respect to data protection, and I'm now sitting on an IEEE standard that Lily Coney talked about the other day for mobile devices. It's so random. That is the problem and you know, you're only one little person and you're trying to wear multiple hats. I'm going to watch how Neil fares after another year of trying all these out when he tries to figure out, okay, which ones can I possibly jam into my agenda? I think that's one of the flaws of the multi-stakeholder model. And it's a problem. One of the questions I have as I look at why the data protection commissioners are being ignored, is it because they haven't come and joined ICANN and sat on one of the, like, you have to be there to have a voice? I'm afraid that is the answer. Yeah. You have to be there.
You have to be there.
Fundamental flaw.
We had another question over there, I think, and then we can move on to thank you.
Hi, my name is Juraj, and I'm from the Data Protection Unit of the European Commission. I have a question for Niels, actually. I was wondering, these models that we now see on the screen, but you had several other slides that were similar to this, just about other human rights. I was wondering whether there is an analogy, or I got something completely wrong between what we try to put in our data protection EU legislation, namely data protection by design, privacy by design. So is this like human rights by design, what you are suggesting here? That's the first question. The other question is a broader question, so anyone who feels like can answer. I was wondering, I see that you are trying to ensure compliance with human rights standards, but I was wondering whether these human rights standards should be rethinked in this era of technology development and things like big data and Internet of Things and just internet as it is nowadays. Are those human rights standards, even if you ensure compliance with them as we know them in a traditional way from the post-Second World War era with the Universal Declaration of Human Rights, European Convention and so on, are they good enough? Are they meeting the societal needs that we are facing in the 21st century? Thank you.
Thank you very much. So, if I would be cheap, I would just say yes and no to the second. But I'll let me elaborate shortly. So what we're trying to do is first come up with concepts to translate human rights into technical terms on the protocol level, and that wasn't done thus far. So we didn't just come up with these things. So we mapped currently 6 cases of where protocols impacted human rights, either positively or negatively, and then try to come up with these concepts to see where they strengthen, when they might harm. So we're trying to come up first with what is the relation, and then secondly, how could we protect them? So yes, that's what we're trying to do. But other than with data protection, and that's where we go back to Lessig, is that protocols are voluntary. So the only thing we can do is say, dear protocol designer, please think about this. So that's an advantage that you have, even though implementation can also be hard for you, I know, but so it's even harder for us. And then secondly, is compliance enough? And say, I don't know, but we will never know if we do not try. Right now we have only language on security and privacy. So it starts with a translation, then with the implementation, and then evaluation, and see what we could and should do more.
I think we had some more questions. Yeah, at least I see 2 hands. Please go ahead.
Hello, Andrew Adams, Meiji University in Tokyo. I must admit to a bit of a guilt trip on this because I've been a member of NCUC for many years. Stephanie may recognise my name from some mailing lists on there, but I have contributed very little, just the occasional internal piece.
There's always time. Join the PDP.
But that's my issue. I'm a very busy professor, and what can be done to try and carve up this work more precisely so that you don't, because my problem here is I don't see that I can have an impact in a positive way. I'm thinking of Brooks' Mythical Man Month idea here, that if I got involved in these, I could not put enough time in to pay back the time that people like Stefania would have to spend getting me up to speed on what's going on. If you can try and carve these things down into areas where somebody like me could say, I will take on this little bit and do something for you. And then in 3 months' time, when I've got a little bit more time, I can take on that little bit. Can you see that there's anything you can do in that sort of area to make it easier for people to contribute and help you out?
I can tell you with great passion, after grinding myself to the bone on these committees since 2013 when I started, I'm committed to finding a way to do this. One of the problems is the setup of the PDPs. I mean, I'm in there. There are weekly calls. As was mentioned, they're in the middle of the night. You can barely keep up with the reading, and it's wonderful to have all this open access, but you're drowning in the fire hose, you know. I try to give the NCUC list, which is the non-commercial users, and then there's another one, the non-commercial stakeholders group, a privacy update every couple of months, and I discovered to my shock and horror that I'm overdue on the last one, just to bring them up as up to date on what's happening. As was mentioned on the other side, I forget who it was, there's so many groups. While we're working on who is, there's a thick who is group that is basically undermining everything that we're trying to do in data protection. It's almost impossible to keep up. You do need an army. And so I'm trying to mobilize. Now, on this particular new PDP, there's already over 120 people signed up. I've been trying to get Niels to sign up, but he says he's too busy. I'm crushed. But there is also an observer list, and unusually, they have said that you can pull in the observers from the observer list later if they wish to switch. So I've been running around trying to persuade academics and folks that have been at ICANN and left to join the observer list. I actually talked Michael Frumkin, who you might be aware was very active in ICANN at the beginning and then wisely fled the room. So he's on the observer list. I promised I would only drag him in where required. So please, join the observer list and I'll carve out a little piece of work for you.
Okay, thank you so much. We had another question or two, I think, yeah? Let's go ahead. The gentleman at the back was waiting for longer, and then let's
don't give him the mic.
I'm Patrick Pennings, Department of Information Society of the Council of Europe. Just two quick things, one on multi-stakeholderism and the second on human rights. I think the Council of Europe strongly supports the multi-stakeholder approach. That is quite clear. There are, as we saw, very different models, and I wouldn't call it a new ideology, but different models of how to cooperate together in order to shape an environment. That's one thing. And the second, about human rights and whether the existing standards are adequate. Human rights and the European Convention on Human Rights is a living instrument. It's not something that is carved in stone forever. There is the case law of the court on the one side, but also there's a lot of soft law being developed. And I can only refer to two things that are currently in the pipeline. One being a draft recommendation of the Committee of Ministers on Internet freedom. And that sets out quite clearly, spells out quite clearly how we should interpret that, basically. And if this is adopted, I think it will have far-reaching consequences on how governments are recommended to act towards the internet, including surveillance, including freedom of expression, including freedom of assembly, etc. So I would just like to refer to that. Thank you.
Yeah, thank you so much. I think that generally we agree that these standards never lose value. These are principles. These are not particular rules that spelled out exactly how or this should be done. So I think we generally agree that the concepts are living and changing and could be adapted to the changing circumstances. Let's have the last question. And
hello.
Oh,
is this
I
on?
thought it was
okay.
There. Okay.
Okay, Tobias Mahler, University of Oslo. I was involved in ICANN some years ago and quit for similar reasons because I couldn't keep up all night and talk over the phone to lots of other people. My question, or rather comment, is a bit related to the overarching issue of having this governance structure as ICANN is and the disconnect with human rights law. I think there is some relatively clear disconnect between the current governance model, which is outside a framework of binding obligations under public international law, and that's different from the states. So states are bound by human rights law. They have to commit to do that. ICANN is discussing whether it should do that or not, and I don't think it's a problem we can't fix, but I think it's a problem we really need to fix. If we are moving outside of the previously traditional governance structures and into something new, which I think is a good idea, then we also need to reflect on how we can set some limitations in terms of binding commitments under human rights law. And that might also then point to some other connections that are missing. Because you mentioned, Stephanie, the fact that ICANN just answers, oh, thank you for your letter, we'll get back to you. In other contexts, there are binding obligations and you have to commit to something. And for ICANN, this is just somebody writing to us. And the third point I wanted to make is that, yes, obviously you have to be present, but governments are already present. They have the GAC representatives, and they have just not involved the right people on that.
Okay, could we please take the last question from, no? Then we will give a floor also to Andrea.
Standing up because we need to...
Yeah, wrap up.
Just 30 seconds. Thank you so much for having organized this session, and thank you for participating and for the questions. I work at ICANN. We have an office here in Brussels, so if you have more questions, if you want to throw something at me, go now, I'll be running around. But I mean, think that ICANN is now 18 years old, basically. We are leaving the teens, we are getting into the more mature stage, and think about how the internet, or try to think about how the internet was back then when ICANN was created and how the internet is now. And I think a lot of the issues that ICANN is addressing now is that back then was really a network of networks that a small, very tight community of mainly engineers were working on, and they weren't necessarily thinking on that one day 3 billion of people were using this network. So the tools that were set at that time, they do not necessarily reflect the needs of today. But still the model is nimble enough to evolve and to moderate, to include all other needs and interest and knowledge. So the baseline is basically get engaged. We are doing as much as we can to make these acronyms much understandable and the process is much easier to engage with. And hopefully once we move away from the US supervision, really we can think about a truly global ICANN which includes in its model all the needs and interest of the internet community as large as we can think of. It's a bit utopic, but I mean, the internet itself, if you stop and think, it's kind of an utopic system that it marvels us every day. So let's try to do that. Thank you.
Thank you so much, and let's give a round of applause for all of our great panelists. And we hope to see you somewhere.